The walls are closing in for Nicholas Rekieta. He has been doing everything that he can to get the body cam footage of his arrest and the search warrant nixed. But today, the court came out and said no to all of his nonsensical reasons. Specifically, they said the defendant's motion to schedule an evidentiary hearing pursuant to a Frank's challenge is denied. The defendant's motion to suppress the firearms slash ammunition is denied. All other omnibus issues not argued with particularity or otherwise specifically identified to the court as a contested issue at the omnibus hearing, whether included in the written notice or not, are denied, having been waived by the defendant. So, I'm not going to read the entire document, but we'll probably do most of it here. So, the defendant is charged with 3 counts: second-degree controlled substance possession, a felony in violation of Minnesota statute, possession of a firearm slash pistol slash semi-automatic military-style assault weapon slash ammunition by an ineligible person, and child endangerment, exposure to controlled substances, a gross misdemeanor. So 2 misdemeanors and a felony. Defendant seeks a Frank's hearing and contests seizure of the firearms. At the hearing, the defendant offered and the court received without objection Exhibit 1, application for and search warrant, Exhibit 2. There's just a bunch of, all the exhibits there. I'm not going to read that. All defendant offered and the state objected to Exhibit 6, recording of the Steel Toe Morning Show from May 22nd, 2024. Admissibility of Exhibit 6 under advisement. After review, the court determines Exhibit 6 is admissible as an offer of proof. The state uploaded Exhibit 10, Nick Rekieta stream, on August 30th, 2024, after technical difficulties with previous Mendez uploads. Supplemental report 8, uploaded on MDES and referred to in defendant's reply memorandum, was not offered or received at the hearing. Following a brief schedule, the court took the matter under advisement on September 6, 2024. Based upon the files, exhibits, records, proceedings, and being fully advised in the premise, the court makes the following findings of fact. On May 22nd, 2024, Quinn Pomplun of the Kandiyohi County Sheriff's Office submitted an application for a search warrant, supporting affidavit, and search warrant regarding Nicholas Rekieta's house. The address subject to the search warrant was known by Deputy Pomplun to be the defendant's residence. The search warrant was for controlled substances prohibited by law, paraphernalia commonly associated with the sale/use of controlled substances, and items that show controlled substance use that are not legal drug paraphernalia. The search warrant was signed by a district court judge on May 22nd, 2024. The search warrant application states that on May 16th, 2024, Kandiyohi County Sheriff's Office Sergeant Dave Nestor received a report of possible child neglect and controlled substance use involving defendant and his minor children. Because remember, the 9-year-old tested positive for cocaine. It was like 5 or 10 times the base level reading to test positive. Deputy Pomplun reviewed defendant's social media videos. Deputy Pomplun notes that the defendant's appearance in the videos changed from January 2024 to May 2024. So even the cops are saying from, January, February, March, April, May, and then like 5 months, they're saying, yeah, he does look worse. His changes in appearance are noted as common with controlled substance users. Deputy Pomplun reviewed Aaron Imholte's social media videos. Imholte hosts his own social media video program. From watching Imholte's videos, it is apparent that defendant and Imholte previously had a friendship and have since had a falling out. Imholte states in videos that he has recently experimented with cocaine and Molly. So, shout outs to Steel Toe Morning Show in the legal documents there. Definitely, that's a win for the toe. On May 22nd, 2024, Imholte uploaded a video where he spoke about defendant and insinuated defendant was using controlled substances. During Imholte's May 22nd video, he referenced a video posted by defendant on May 21st. Imholte notes that white powdery substance can be seen on defendant's nose during defendant's May 21st video. Defendant's May 21st video was removed from the internet. Yeah, probably a good call, but doesn't seem to have been effective enough. Deputy Pomplun was able to review defendant's May 21st video. Defendant's video is 4 hours and 4 minutes in length. At approximately 2 minutes and 46 seconds, defendant leaves the video to use the restroom. Upon his return at approximately 2 hours, 50 minutes and 40 seconds, so like, 2 hours and 48 minutes later, defendant appears with a white powdery substance on his nose. Defendant's demeanor is excited. At one point, he closes one eye to be able to read the screen, rambles, and slurs his speech. Deputy Pomplun was previously a drug recognition evaluator. Based on Deputy Pomplun's training and experience, defendant's behavior on the May 21st video indicates polysubstance abuse. Deputy Pomplun notes defendant's behavior is consistent with using both a central nervous system stimulant and depressant. Deputy Pomplun's summary of Imholte's May 22nd video and defendant's May 21st video are accurate. Oh, so it's kind of funny. They say polysubstance abuse there. So there's a polycule, a polysubstance-filled polycule. There is no indication that law enforcement viewed an altered or edited version of defendant's May 21st, 2024 video, even if it was not the original posted video. Because Nick was basically trying to argue that because there was a watermark, it's not the original video, you can't watch it. But the court is like, no, it's the same video, right? Like, it's not been modified in any meaningful way. It's the same video, bro. On May 23rd, law enforcement officers executed the search warrant at defendant's residence. While at the residence, the following items were found: a black vial with white substance inside in master bedroom near nightstand. Both items field tested positive for presence of cocaine. I don't know if this is exactly what they're talking about. I heard it's like a pendant thing, and you put a little cocaine in there. I think that's what that is there, but I don't know for sure. A yellow snort tube in master bedroom near nightstand, field tested positive for presence of cocaine. Two 22 caliber spent shell casings in master bedroom near nightstand. Sig Sauer AR with several magazines and loose ammunition in under bed in master bedroom. Glass container with metal filter and grinder in master bedroom dresser, field tested positive for presence of cocaine. 45 caliber bullet in the master bedroom closet. Bag with cards and dollar bill in master bedroom safe, field tested positive for presence of cocaine. Corner cut baggie with white powder in master bedroom safe, field tested positive for cocaine. Like, he has this all over the place. Is it really so hard to believe that the kids would have gotten into it? Not to me. 3 small baggies in master bedroom safe, field tested positive for cocaine. Green colored tablets in master bedroom safe, field tested positive for ketamine. Digital scale in master bedroom safe, field tested positive for cocaine. Metal pan with white powder in master bedroom safe, field tested positive for cocaine. 2 snort tubes and 2 metal cutters in master bedroom safe. Snort tubes, field tested positive for cocaine. $100 bill with white powder residue in master bedroom closet safe, field tested positive for cocaine. Bindle white bag with white powder substance in master bedroom closet safe, field tested positive for cocaine. Cocaine scooper in master bedroom closet safe. I didn't know that was like an official law enforcement term, a cocaine scooper. 2 baggies with a baggie with a funnel in master bedroom closet safe. Unknown brown substance in master bedroom closet. Field tested positive, or field tested negative, sorry. I think I remember people speculating that that was like some um, leftovers from when you do a drug. Like, if you're smoking weed with a pipe, it gets that resiny stuff or whatever built up. People were speculating it was some version of that for other drugs, but it sounds like it didn't test positive. Springfield Armory 45 caliber 1911 in garage closet safe. Sig Sauer 380 handgun in garage closet safe. 4 45 caliber magazines and 2 38 caliber magazines full of ammunition in garage closet safe. 45 and 223 ammunition in garage, and Remington 870 12 gauge shotgun in garage. The total measurable weight of cocaine found during the execution of the search warrant was 26.67 grams with packaging. So, okay, even with the packaging, it's a little bit short of the ounce then. And, sorry if I mispronounce any of your gun words, guys. I don't know those. The information contained within the search warrant was accurate and reliable for the reviewing judge. There was no clear false statements, significant material omissions, or material misrepresentations that caused the search warrant to be false, misleading, or in violation of the defendant's constitutional rights. All facts contained in the memorandum of the court are incorporated by reference as findings of fact. And now we're back here. The defendant's motion to schedule an evidentiary hearing pursuant to Frank's challenges, denied. The defendant's motion to suppress the firearms ammunition is denied. All other omnibus issues not argued with particularity or otherwise specifically identified to the court as a contested issue at the omnibus hearing, whether included in the written notice or not, are denied, having been waived by the defendant. Court administration shall schedule a settlement conference. The memorandum of the court is incorporated by reference. And there are actually a couple more interesting parts as you go on here. Defendant appeared at his omnibus hearing charged with 3 counts. Defendant challenges the validity of the search warrant and moves for a Frank's hearing. Defendant also challenges seizure of the firearms during the search warrant's execution. Warrant challenges. Defendant argues Deputy Pomplund made false statements or recklessly disregarded the truth in the search warrant affidavit. Defendant points to the following in support of this contention. So that's kind of what his argument here was contingent on, is he had to prove that Deputy Pomplund made false statements or recklessly disregarded the truth, and then the whole warrant gets thrown out and he's basically good to go. Defendant points to the following in support of this contention. KCHHS determined a report of possible child abuse did not fit the definition of child abuse or neglect. Imholte and defendant no longer had an amicable relationship, and defendant alleges Deputy Pomplund watched defendant's YouTube video on a third party's YouTube channel. Can you believe that? An archive? A re-upload? You'd have no idea what was really going on. The United States and Minnesota constitutions guarantee the right of the people to be... Oh yeah, that part's generic. I don't need to get into that part, I don't think. Defendant next argues that Deputy Pomplund misrepresented the relationship between defendant and Aaron Imholte. The affidavit states throughout Imholte's video blogs, it is apparent that they and the Rekietas were friends and may have recently had a falling out. Defendant asserts that Imholte and defendant's relationship has deteriorated beyond a mere falling out. So Nick is like, no. You are being reckless by saying that Aaron Imholte and I had a falling out, all right? It was much worse than that, all right? Feelings were genuinely hurt. It's deeper than a falling out. Very, very funny excuse, but, didn't go too far for him. I guess the court didn't appreciate the humor of that excuse. The affidavit further explains that Imholte posted a video on May 22nd where he speaks about defendant and insinuated controlled substance use by defendant. However, Deputy Pomplund also included information that Imholte admitted to recent controlled substance use, which is essential information for the reviewing judge to determine veracity. The case background provides sufficient information to provide context of the relationship between defendant and Imholte, veracity of Imholte's statements, and provides accurate information about Imholte's video from May 22nd. The information provided by Deputy Pomplund about defendant and Imholte does not amount to misrepresentation. It accurately describes their relationship and includes information necessary to determine veracity of any statements. Importantly, the information within Imholte's videos is not the sole basis of the search warrant, and certain statements of defendant's drug use were corroborated by Deputy Pomplund's own observations of defendant's video with powder on his nose, consistent with illegal controlled substance and behavior consistent with being under the influence. So they're like, yeah, no, that's dumb, and also we got more, basically. Defendant's final claim is that Deputy Pomplund did not view defendant's original May 21st video from defendant's YouTube channel, but rather watched the video from a third-party channel that reposted defendant's video and did not watch the video in its entirety. The search warrant affidavit states, your affiant was able to review the video that was taken off of your YouTube channel and Rumble social media sites. The video is from 5/21/24. Deputy Pomplund notes that defendant appears to be drinking an alcoholic beverage, and later in the video, defendant appears with a white powder on his nose, and behavior indicative of controlled substance use. The case background states that the entire video is 4 hours and 4 minutes long, and at approximately 2:46 into the video, defendant leaves to use the restroom. When he returns at 2:50:40, he appears to be making an excited look and has a white powdery substance on his nose. Deputy Pomplun also notes that during the YouTube video, defendant has to close one eye to read the screen, rambles, and slurs his speech. It's a very accurate description of that stream. These above stated timestamps described by Deputy Pomplun are consistent with the defendant's May 21st, 2024 video uploaded by the state. Based upon the court's review of the video, Deputy Pomplun's descriptions are an accurate representation of defendant during the May 21st video. It is unclear if Deputy Pomplun viewed the video from defendant's YouTube channel or from a third-party channel. The state noted that the full video from defendant's YouTube channel was disclosed to defendant on July 3rd, 2024. Even if the video of defendant was a copy taken from a third-party posting, there is no suggestion that the content itself was doctored, clipped, altered, or otherwise changed. Defendant also argues Deputy Pomplun did not watch the entire May 21st, 24 video and only watched a 1-minute clip contained on a PowerPoint. The PowerPoint clip contained in Exhibit 2 shows that defendant's video is 4 hours long. When that image is cross-referenced with the full video of Exhibit 10, the same image appears at the corresponding timestamp. Exhibit 4 is an image that is purportedly taken from the clip in the PowerPoint file. When the image of Exhibit 4 is cross-referenced with the full video of Exhibit 10, the same image appears at the corresponding timestamp. There is no evidence that the images of Exhibit 2 and 4 are an inaccurate depiction of defendant's May 21st video. Most notably, Deputy Pomplun asserts in the affidavit that he watched the entirety of defendant's May 21st video that was disclosed to defendant and provided to the court. So he's saying, no, I watched all 4 hours, bro. I'm on to you. The court does acknowledge that using social media video as support for a warrant is somewhat unusual, and caution must be used to ensure an altered video, parody, etc. are not used as support for a warrant. In this case, there is no indication that Deputy Pomplun did not watch the defendant's May 21st video, nor is there any evidence that the video is altered, a parody, or otherwise inaccurate. There is insufficient evidence to show that Deputy Pomplun made statements or omissions in the search warrant affidavit that were false or reckless in disregard of the truth and material to the probable cause determination. Therefore, a Franks hearing is not required. So they don't even want to hear it out. They're just, no. And then this last bit is in reference to seizing the firearms. Most of it is just like boring, referencing the lie. But here the search warrant provided that the police were entitled to search the premises and defendant for controlled substances, including methamphetamine, cocaine, or any other controlled substances prohibited by law, and paraphernalia commonly associated with the sale/use of controlled substances, items that would show controlled substance use that would not qualify as legal drug paraphernalia. Law enforcement had a valid warrant to search for the items of the kind described in the warrant. Therefore, under general rule regarding the permissible scope of valid premises search warrants, officers were authorized to search all areas inside defendant's residence where one would reasonably expect to find those named controlled substance items, including any containers that could conceal such items. So everybody's saying, anywhere where somebody potentially would have drugs, we're allowed to search. So if we find guns or something along the way, that's all good. During the course of searching for the items named in the warrant, firearms and ammunition were discovered in areas where drugs could be kept during the search. The evidence of controlled substance use was also found during the execution of the search warrant, namely controlled substances and paraphernalia field testing positive for controlled substances, which allowed for immediately seizure and possession of firearms/ammunition as evidence for possession of firearms by a user of controlled substances. Yeah, don't want to be mixing the guns and the illegal substances. The seizure of the firearms/ammunition was lawful. Defendant's motion to suppress such evidence is respectfully denied. Probable cause challenge. Defendant made a vague passing reference to a probable cause challenge on page 8 of defendant's reply memorandum filed September 6th. This probable cause challenge is untimely and was not properly noticed or raised at the hearing. So, yeah, no good. And then this is I never saw it at the time or whatever, but supposedly this was actual merch that Nick put out before losing some case. I don't know of the full Rekieta lore, just in passing. But so yeah, they they put out this merch that says, "Damn it, Nick, we lost the case again." There's another shot of it there, a little bit clearer to read, but yeah, pretty on the nose merch. And then this is, I think this was on his locals that he posted this, but maybe it was Twitter. I can't tell. Omnibus hearing. I think people will be surprised by the outcome because they have really bad legal analysis coming in from the Kiwi Farms law couch. Well, Nick, turns out you were wrong. And all of the non-practicing lawyers, the practicing lawyers, the non-lawyers, just about everybody except for you was right. And like what, Barnes or something, that guy. But yeah, so shout outs to the Kiwi Bros. That's where I got all of this. And it's just so nice to see because he's just such a smug prick about it. Right? I think most people would be down for a redemption and rehab and all of that and kind of root for him at least, but he's just such a smug, arrogant prick about all of this. So it's very, very satisfying to see it not work out for him. Like, there is nobody except the absolute fanatics that has any sympathy for him at this point. And that is just entirely his own making. And it's crazy to think about where he was with the 100,000 concurrent viewers, the Johnny Depp Amber Heard trial, the Rittenhouse trial. He was like that guy on LawTube. And now he's that guy. Ugh.